The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Seven cases will be submitted this afternoon. Those cases are Darla Legg and Jason Legg versus West Bank. And then there is a companion case with the same parties. The third case is in re the marriage of Richard Maurer and Carol Maurer. Fourth case is Wellmark Inc. versus Polk County Board of Review. Fifth case is Kevin Brandt versus Robert Rimrod, Lori Lynn Parr, and Galco General Insurance Company, or Geico. Sixth case is Iowa's Supreme Court Attorney Disciplinary Board versus Paul Silch. And the last case is Iowa Supreme Court Attorney Disciplinary Board versus Alexandra Nielsen. The second Legg case, the Bryant case, and the last two disciplinary cases are now submitted, and we'll now hear the arguments in the Legg case. Mr. Hauser.
May it please the court? This case involves claims about checking account non-sufficient funds fees charged by my client West Bank. The first type of claim, first group of claims involves a usury theory under the Iowa Consumer Credit Code. West Bank's first three arguments are independently dispositive of the usury issues. The court would only have to decide one of those issues in favor of West Bank in order to reverse. The first argument that I want to address is whether the funding of an NSF transaction is, quote, credit, end quote, under the statute. If there is no credit, the UCC does not apply and the UCC or the usury claim fails. West Bank acknowledges that funding an NSF transaction is a loan or an extension of credit under the common law. It's also a loan as defined under the ICCC. That does not mean, however, that it's credit. A credit and loan are defined differently under the statute. Credit as defined in the statute, the key concept is there has to be a right granted by the creditor to defer payment of debt. The dispositive factual circumstance here is that West Bank did not grant plaintiffs any right to defer the repayment of the overdraft item. The court's opinions, this court's opinions in Anderson versus Nextel, which was decided in 2008, and State Ex Rel Miller versus NFO, which was decided in 1979. Those cases illustrate how this issue should be decided. What the court did in those cases was it examined the parties' agreements, it determined whether there was a right to defer payment, and it determined whether or not there was credit on the basis of that. In both of those cases, the court found that the statute was not applicable. Here, plaintiffs argue that there was a right to defer payment because the payment of the overdraft is not made until at least the next day, usually when a deposit is made in the account and the funds are offset. That theory that a delay in collection is the same as credit under the statute is refuted by this court's opinions. Plaintiffs also argue that the funding of these NSFs was a consumer loan as defined under the statute. The fallacy in that argument, however, is the definition of credit is embedded in the definition of consumer loan. The question of the consumer loan definition just begs the issue of whether or not there's credit under this statute. The record contains a couple of statements, bulletins, and formal advisories that have been issued through the years by the Iowa Division of Banking and the Iowa Attorney General's Office. Plaintiffs rely on those bulletins to a certain extent concerning this argument. However, those bulletins, to the extent that they either state or infer that there might be credit in the funding instance under the statute, the specific credit issue that's addressed here and raised here was not decided in those bulletins. Those bulletins are obviously not binding on this court, and it's this court's chore to make this decision. The final thing the plaintiffs rely on in this argument is the pendency of this case in the trial court's ruling caused an amendment to the ICCC in 2014. Plaintiffs argue that that amendment creates an inference that the Iowa legislature thought that the funding of an NSF would have been covered by the statute before the amendment. West Bank suggests that the amendment was a creature of substantial sausage making, which we all are familiar with in the legislative process. And today, for today's just period, I don't think that the amendment casts any inference on what the statute was before the amendment. This first issue is a narrow and easy way to dispense of the usury claims in this case. The other two issues are a little bit more complicated. The second one I'm going to talk about is the issue of whether the fees or finance charges as defined in the code, quote, finance charges, end quote, as defined in the code, or account maintenance fees that are outside the statute altogether. Both the Iowa Division of Banking and the Attorney General have historically believed and said and inferred that the initial overdraft charges did not violate the ICCC.
Can I interrupt you
go
just
ahead.
for a minute? I'm interested in some facts here, and I understand the NSF fee is $27 or $30, something like that, if
Right.
I remember correctly. Yeah, I think so. And it's, if I also remember from the record, it's kind of a automatic charge.
No, the record in this case is undisputed that the charge is allocated, is determined and levied by a bank officer who reviews every single transaction to make the decision whether or not the charge will be imposed.
Okay, so you say the $27 then, under your theory of the case, is a fee, if you will, because you have human eyeballs staring at a transaction.
Right.
And the $27 is what, a reasonable effort to recover your costs from having to eyeball the record.
The record in this case is that West Bank sets its fees at the about or lower than what the fee, the average fee is
I'm not worried
in
about
the
the
market.
average fee. I'm not worried about the average fee, because it could be that the participants in the market see this as an opportunity to raise money. I mean, we hear that from the plaintiff's position.
Right, but the key point that I was trying to make, Justice Apple, was West Bank, the testimony was, I believe it's in the appeal record, but the testimony was West Bank doesn't account for the cost. It sets the fees at approximately or a little bit lower than what the fees are in the marketplace, and the fees are for the efforts that are expended in response to the presentation of a negative dollar amount item.
Are you relying on the 2013 guidance from the Superintendent of Banking, and what weight should our court give to that?
We are relying on the guidance, and I think the guidance is entitled to some deference. It is obviously not binding on this court, but it does explain the banking law context in which the distinction between an account maintenance fee and a funding fee has always been maintained. That is a familiar concept in banking law, and it underlies the guidance.
The Superintendent of Banking, or the Department of Banking, has interpretive authority, correct?
Yes, as interpretive authority under the Iowa Banking Act, it is also charged with the responsibility to enforce the ICCC on banks under the ICCC itself.
It doesn't have authority to interpret the ICCC, or does it?
Yes, it does. It has specific authority to interpret all statutes that apply to Iowa state banks, and that's found in the Iowa Banking Act, and the section is cited in our brief.
Is it also true that this fee is charged only when the bank covers the NSF?
That's a very interesting point, Your Honor, and I'm glad you asked that question. The plaintiffs here argue a but-for relationship between the fee and the funding. However, they disregard the forced pay characteristic of the card transactions. Cards, because when you use a debit card, it functions like a credit card to the extent that when the merchant takes it,
But if
Isn't it
they,
kind of,
but if the fee has to be, if the debit card has to be paid, why does anybody have to look at it? I mean, there's gonna be a fee every time on the darn thing, unless they have a special account, of course, but
isn't it kind of how you slice the onion a little bit? As I understand it, you can have NSF fees on items other than debit card charges where the item is not paid. Isn't that correct? And the only reason you can't have them on debit cards is because the item has to be paid because the merchant has already honored it, and under the merchant agreement, you're obligated to pay them. Yeah, right. Return them. I misspoke. Yeah. Okay. And I think you're referring to something I wrote in Bagelman about it with that attached word. But in this case, your depositor agreement expressly imposed a good faith obligation on your client. So doesn't that make it different? This is not an implied obligation of good faith, but it's one that you undertook in a contract. Just worry about the one in the contract. So your argument is that the contract incorporated not just a duty of good faith, but the specific definition of good faith from the UCC. Is that what you're saying?
If you look at the UCC, on this issue, it says they have no rule on priority of paying checks. But if you read the comment, the reason they don't have a rule is because they can't do one. It'd be impossible. The rule would be hundreds of pages long because there's all different situations, and that's comment 7. So it goes back to incorporating some kind of good faith obligation to pay those things when you put the comment together with the law, together with the good faith standard. And that's my problem in this, you know. And they say, as between one item and another, no priority rule is stated. This is justified because of the impossibility of stating a rule that would be fair in all cases. So it indicates to me that it has to be fair in this case and good faith. And fair would, to me, would seem paying it the other way when you work off the comment and you work off the statute. I mean, how do you answer that?
Thank you, Mr. Hauser. Mr. Brady.
Yes, but I understand that, but Mr. Hauser says the record shows that although the task might be somewhat different, he says that for each debit card NSF, there's actual human eyeball review and so forth. What does the record show?
All right, but I understand this argument that the debit cards are different than because at point of sale, once the merchant takes it, if the merchant's told there's money there and the merchant takes it, then the bank has to honor it. But here's a question: the definition of credit is the right granted by a person extending credit to a person to defer payment of debt. Now, in this case, if the bank pays a debit card transaction where there aren't funds in the customer's account, and the customer 10 seconds later walks into the bank and makes a deposit, the bank is going to grab its money, right? So where is the right to defer payment? And that's true. I accept that, but focus on the language, a right to defer. Where is the right that's being granted? That's like saying if my son, my 13-year-old, I've got $20 on the shelf and he takes that to go, spend for lunch money, I've extended credit to him.
Well, but most banks at this point, or credit unions or banks, they already have a device like that that's set up. I mean, they have check protection, they have lines of credit, they have any number of other things. This, we're talking about a very, very specific thing, which I think is different than what you're talking about, which would be a check protection or a specific agreement that we're going to cover that for you and take it out of a quick draw account, and then we'll charge you something for it.
Well, but wait a minute. I'm sorry. I want to be very straight with you. The language is right to defer. Now, what I hear you saying is, as a practical matter, a loan is extended because you cover the bank covers the overdraft, and it takes a period of time before cover is provided. And so, as a practical matter, there's arguably a loan, but the language of the statute is right to defer. It strikes me fairly simplistically that vests a right on the part of the consumer to postpone payment. And I'm not sure that's quite what we have. As a practical matter, we have a short-term loan. Yeah, oh, surely. That's why I'm asking the question. So if I'm a contractor and I just fixed your basement and I give you a bill and it's due, here's my $1,000 bill, and somebody says, well, I'll pay you next week, and I say, okay, is that extension of credit?
This isn't an ad hoc agreement. You have no
yeah.
means of repaying me.
only allowing it until you can get the money. I mean, there's no term, there's no, if the customer said, can I pay in 30 days, can I pay in 60 days, none of those rights exist.
If it is the loan, do we have to wait until it's paid back to determine the interest rate? Because what if the person ceases doing work there and they don't get the bank doesn't get their money back for 2 years later? $27 may not be usurious.
Your time's running out, but I'd like to ask you about the good faith issue. And Mr. Hauser has stated correctly, I think, that generally speaking, you know, we've all dealt with good faith problems in contracts, and ordinarily, you have to tie it to a contractual provision. But what's interesting here is there is a contractual provision, although it's stated in terms of good faith. His suggestion as well, it basically incorporated the UCC. What's your view of that? I think you're saying, and correct me if I'm wrong, but I'm trying to follow this through, but I think you're disagreeing with Mr. Hauser. Mr. Hauser says the good faith requirement in the contract simply incorporated the UCC, and you're saying, no, the good faith provision is an independent contractual provision that can be enforced, I guess.
Does your claim depend in part on the customer's expectation that they were only going to be charged the low to high? Does that complicate class certification? Are we now into individual assessments of what customers knew or not, or is this can be made kind of across the board? But if there's no law requiring them to use a particular sequence, how is it bad faith for them to change from low to high to low?
Thank you as well, Counsel. Mr. Hauser.
Aren't there good faith cases that say that notice is kind of a component of good faith, that you? Oh.
Isn't it your position basically that the good faith provision of the contract is a redundancy because the UCC provision kicks in? I mean, what's the independent meaning of the good faith beyond the UCC? Well, tell me what it is. The scope of the good faith obligation, I understood, and I'm sorry to be redundant here, but the scope of the good faith obligation is no broader than the UCC obligation, I thought you said.
There is kind of a concept in contract law that if you sort of have a discretion in the contract, you can't use it to kind of make the other side's life miserable. I mean, I think there are some limits on that. Like, you know, if I hire you to paint my house to my satisfaction, and then you get up there and you paint the house, and I say, well, I don't really care for that. I'm not going to pay you. A court will step in and apply some reasonable criteria to limit my discretion. And doesn't that principle come into play here or not? You give me too much credit.
Thank you as well, Mr. Hauser. The case is now submitted, and we'll stay on the bench, but just take a short break. But the attorneys can come up for the Mauer matter.